Thank you, Mr. Chairman. Thank each of you for your testimony. I find myself in a very difficult spot. I don't know that I have, on many occasions, ever agreed with the ACLU. And I don't know on many occasions that I've ever gone against law enforcement. And yet, this fundamental question that we're here today addressing is, Mr. Downing, very troubling because of the expectation of privacy and what foundationally is what all Americans presume that they should enjoy. And so I guess under what scenario can you justify not sharing with members of Congress the Jones guidance? And let me caution you, because I go into a SCIF here and I see all kinds of national security secrets that I'm not allowed to divulge, and yet somehow your Jones guidance would supersede our nuclear capability in terms of my ability to see a memo.
As I've said before,
is it more important than our nuclear capability?
The department is very much interested in providing whatever information the
so you're going to provide it to all the members?
At this point, there are,
because having an interest in doing something are two different things, Mr. Downing. So are you going to provide it to the members of Congress? I get to see all kinds of national security secrets, some that you may not even get to see.
We are seeking to do an appropriate accommodation with the committee.
Appropriate according to who?
Mutually appropriate accommodation.
Well, we think it's appropriate that the entire committee should be able to see it. So
the gentleman who yielded.
Yes.
I don't think we should be treated any different than every other member of Congress. I've been fighting this for years. And even though we're grateful, it's amazing to me that I have to negotiate as a member of Congress, as the chairman of the committee, as somebody who also serves on the Judiciary Committee, to an accommodation. I mean, part of this deal is we're not supposed to take notes. We're not supposed to do certain things. What? Seriously? That's the reason I've resisted every other gesture thus far is because of all these conditions. I shouldn't have to have a condition. I represent 800,000 people. They trust me to go in this republic and look at this information and keep it confidential. That we sign oaths, we abide by the law. If we don't do that, then we should prosecute us. But we see, as Mr. Meadows said, some of the most sensitive information that you can possibly have. But the guidance on Jones, post-Jones, is somehow so sacred that thus far you're only granting 2 out of 535 people to go see this? It seems very inconsistent. I'm sorry, I yield back to the gentleman.
Go ahead, you can comment.
It's not really a matter of trust. I think that's not the right way to think about this. The department has confidentiality needs in things like the positions that we're going to take. We're also worried that disclosures of one sort will be regarded later by a court as a waiver of a privilege as well. So there's a number of factors that go into this consideration.
But it is a matter of trust, because if you're saying that you can't, I mean, because we're protected in that. If members of Congress, maybe not our staff, but members of Congress would be protected. But let me go a little bit further, because what you're saying is reasonable suspicion is enough to be able to use this. Is that correct? In some cases.
For the historical cell site information, yes.
All right, so is it okay for the IRS to use reasonable suspicion as their guidance?
If what we're talking about is historical cell site information, they would have the same rules as all the other law enforcement.
All right, so let me ask you, is when we've had this whole Lois Lerner thing, and I don't normally harp on that, but they had reasonable suspicion, according to them, according to DOJ. They had reasonable suspicion. So what you're saying is they could use a stinger for every single group that they had out there that was asking for 501c4 status.
I don't have any
well, that's what they're saying. It was DOJ that we actually had a hearing the other day. So that's troubling to me that we would do that. Wouldn't it be troubling to you?
I think there should be a consistent standard for all law enforcement investigations. And the one that...
Well, the consistent standard should be probable cause, wouldn't you think, with an expectation of privacy?
There are particular situations like the shooting at the judge, though, that cause the probable cause standard to not be...
I don't know of any Tea Party group that shot anybody. Do you?
I don't.
So let's not talk about shooting of a judge and comparing it to the IRS. I mean, because you're somehow justifying that that would be appropriate.
I'm merely saying that
they can use your same standard. So what about...
There ought to be one standard.
All right,
yes.
So is it breaking the law if a criminal buys a Stingray and they start to use this?
Yes, it is.
Now, why would that be? Because there's no probable cause standard.
Oh, no, whether something is a crime and whether something is available to the government under...
yeah, but here's the difference is what you're doing is you're superseding the judicial branch by basically saying the executive branch here knows best. Because what you're saying is we don't really need probable cause and go before a judge because we have this reasonable suspicion standard.
I would emphatically disagree. It's the courts that decide this. And when we have obtained those orders, it's by going to a judge in order to obtain it, and they've signed them. And then it's litigated later. And to date, the 3 circuit courts that have decided this issue that have not had their opinions vacated have ruled that there is no reasonable expectation of privacy.
Here's where I would caution you, and I'm going to yield back to the chairman. This is very problematic in a bipartisan way, and you have a choice here today to start to work it where we can help law enforcement enforce it and still protect our Fourth Amendment rights, or you're going to find yourself without a tool very quickly, because I think there is a bipartisan desire here to make sure that the protection for all Americans is something that they should expect. I appreciate the patience of the chair.
Gentleman yields back. Now recognize the gentleman from Wisconsin, Mr. Grothman, for 5 minutes.